A tribunal use both before the hearing to read their papers and afterwards to consider their decision. All unfair dismissal cases are heard by a panel, usually of 3, as in our case, although it can be heard by 2 people if one is unavailable and the parties agree. The chairman, who sits in the middle, is always an experienced lawyer. Chairmen and their wing members are addressed as Sir or Madam. So, although the tribunal in many ways is quite informal, there are still marks of respect that should be made. You should remember as well to stand up when the tribunal members enter or leave the room. The other 2 members of the tribunal, who sit either side of the chairman, are the lay members, and they're drawn from panels representing employers and employees so as to create a balance. It's really important to remember that each member of the tribunal has 1 vote, so the lay members can, technically, outvote the chairman, though this doesn't happen very often. Whilst the tribunal has to decide the case on the evidence it hears, the lay members can fall back on their often extensive experience of the workplace. The tribunal will usually get together beforehand in their retiring room so as to read much of the paperwork as time permits and to have a preliminary discussion about the issues. This is Julian Kirby, who you saw earlier being dismissed. The advocates in the case, whether or not professionally qualified or acting in person, sit on a bench at the front of the tribunal room. Julian Kirby in this case is represented by Ellen Pennell. She's a solicitor and a partner at Capital Law. The respondent is represented by Hilary Winston, and Hilary is a barrister from Old Square Chambers. The solicitors who've instructed Hilary have sent along a note-taker who sits beside her. Behind Hilary are the respondent's witnesses, Philip Maxwell and Margaret Bradshaw, who, respectively, dismissed the claimant and rejected his appeal. There can be many more witnesses. It really depends on the facts of the case. And remember, the tribunal can pay limited expenses to witnesses. In tribunal cases in England and Wales, witnesses generally stay in the tribunal room whilst other witnesses are giving their evidence. But in Scotland, for example, the witnesses stay out of the room until they give their evidence. At the front of the tribunal, on their own table, is the tribunal's clerk who does the administration for the hearing and will swear in the witnesses later. There are quite a few other people in the tribunal room today. Tribunal hearings are usually held in public, which means that in theory anyone can sit in and watch what's going on. Some of Julian Kirby's friends and family are here today to support him, and we've also got a local newspaper reporter at the back. You can ask the tribunal to exclude members of the public, including the press, but this only happens rarely, such as where the case involves particularly sensitive issues.
Good morning.
Morning, sir.
We'll start with some introductions. My name is David Wong. On my left is Miss Doherty. On my right is Mr. Bowman. Miss Pennell, you're representing the claimant. Miss Winston, you're representing the respondent?
Sir, yes.
Both parties in this case are professionally represented so that you can see how trained advocates would handle it. However, most people represent themselves in tribunal cases, and tribunal chairmen will help unrepresented parties through the process. The chairman will inform them of what they're expected to do and will help them with unfamiliar areas such as cross-examining the other party's witnesses and explaining to the panel exactly what their complaint is.
Thanks to the parties for the well-prepared bundles, which we have spent half an hour or so going through this morning.
The bundle referred to by the chairman is a file of files of all the relevant documents. At least 6 copies are needed, 4 of which are for the tribunal. This is the bundle in this case. So what goes into it? Well, the ET1, which is the claimant's claim form, the ET3, which is the company's defence, witness statements, notes and minutes of meetings, correspondence, disciplinary procedures, handbooks, and any other documents which the parties consider relevant. And if the parties can't agree the bundle, they can each prepare their own. The pages should be clear, numbered, punched, and in a ring binder or lever arch file. There's no guarantee that the tribunal will let you introduce a document not in the bundle, so ensure it's complete. The tribunal has the power, more or less, to run each case and each hearing as it sees fit. In doing this, tribunals try to ensure that the parties are on an equal footing, save expense, deal with cases in proportion to their complexity, and ensure cases are dealt with quickly and fairly.
Ms. Pinnell, I'm assuming from the fact that they appear in the bundles that the parties have exchanged witness statements
Yes, sir.
and completed disclosure. There's nothing outstanding.
Sir, disclosure is complete as far as I'm aware.
Sir, we have nothing further.
You heard Ellen and Hilary tell the panel that disclosure is complete. This refers to both parties' obligation I referred to earlier to let the other side see all the documents that form part of their case. The parties will have agreed or been told to exchange the documents prior to the hearing taking place. All the documents should be in the one bundle which you heard the chairman mention earlier. Parties sometimes refuse to disclose certain documents, and if the parties can't resolve this, then the tribunal will decide what should be disclosed.
Is there any issue over compliance with statutory procedures?
Yes, there is, sir. The claimant asserts that the minimum procedure has not been followed, and consequently that the dismissal of Mr Kirby was automatically unfair.
Sir, the respondent's case is that the procedure was followed and that the dismissal was fair.
The statutory procedure being referred to here is the statutory minimum procedure employers and employees must follow in disciplinary matters. These rules came into force on the 1st of October 2004. The chairman asked whether or not these have been complied with, because if they haven't, there are certain automatic sanctions. For instance, if Hannigan's Brewery hasn't written the appropriate letters to Julian Kirby before dismissing him, or hasn't allowed him a reasonable amount of time before a disciplinary hearing to think about the allegations against him, then his dismissal could be automatically unfair, and Hannigan's Brewery could be ordered to pay Julian Kirby extra compensation of up to 50%.
The panel has read ET1 and ET3 and witness statements. Is there anything else the advocates consider we would benefit from reading at this stage?
No, sir, the issues are fairly straightforward.
Sir, I agree.
So we should be able to get through everything by the end of the day. Let's see. We have 3 witnesses. That's right, isn't it?
Yes, sir, that's right.
Can we look at the issues?
Sir, this is a pure unfair dismissal case. The claimant's case focuses on the respondent's flawed procedure in the investigation and the disciplinary hearing, ultimately leading to his unfair dismissal.
Sir, there is conflicting evidence on what was said and done. It's the respondent's case that following a reasonable investigation, it believed on the balance of probabilities that the claimant had been involved in a scam by allowing customers to drink free at one of the respondent's pubs. Now, clearly, this is gross misconduct, and therefore dismissal was a reasonable outcome in the circumstances.
Thank you, Ms. Pinnell and Ms. Winston. Are there any other preliminary issues that need to be dealt with before we begin?
Sir, no.
No, sir.
You've seen the chairman here asking the advocates to clarify matters. Expect the chairman at the beginning of the case to identify exactly what issues the tribunal will have to deal with in each case. Often, the chairman may ask the parties to clarify a certain part of its case, or he may challenge them on part of it. So be prepared for this.
When preparing witness statements, preparing a skeleton argument, you've got to identify what the issues in the case are. And when you've identified the issues, then you tailor your evidence, you tailor your arguments to those issues. Very often parties just get involved in a diffuse narrative about what the dispute has been, what has happened. That's not the way to go about it. At an early stage, you must identify what the issues are.
So let's recap on preparation. The law. Understand the law and how it relates to your case. Identify the weak and strongest points in your case and decide how best to deal with them. Prepare full written witness statements for each of your witnesses, if you have any. Comply with the tribunal's directions and instructions. And ensure copies of all relevant documents are exchanged with your opponent. And then prepare the bundle of documents.
Ms. Winston, would you call your first witness?
Thank you, sir. I'd like to call Mr. Maxwell, please.
The employer is presenting its case first here because, in unfair dismissal cases, it is for the employer to show a fair reason for the claimant's dismissal. This means that the employer's witnesses will give their evidence first. The person who made the decision to dismiss will usually be called first to explain why they did so. All witnesses give their evidence on oath or affirm. Whilst under oath or affirmation, a witness cannot talk to anyone about the case. And if a witness gives evidence before a lunch break and continues afterwards, they remain sworn for the entire time and mustn't speak about the case during the break. If a witness lies to the panel whilst under oath, this is a criminal offence and they can be prosecuted.
I swear by Almighty God that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
All right, Mr. Maxwell, do take a seat and make yourself comfortable, and have a glass of water if you need one.
One of the first things I ask is, have the witnesses been to a tribunal before? If the answer is no, then the best advice you can give them is go and hear a case. Go and find a case in a tribunal that's comparable to yours and spend a day in the tribunal just to get a feel for what's happening.
The first thing that's very important, I think, is body language, because tribunals do judge a fair amount on personality, and cases are often personality driven. So your demeanour in the witness box is extremely important. You must show respect to the tribunal. The way in which you sit, the way in which you answer questions is all important. Don't question the relevance of the questions when they're put to you. That's for your barrister or representative to do that. If you don't understand the question, ask for it to be explained to you. There's nothing wrong with that. If it's a compound question, ask for it to be broken down. Make a distinction, if you can, between I don't recall that and no, it didn't happen, because there's a big distinction between the two, and people tend to fall into I don't recall that, which is ambiguous. Equally, when you're not giving evidence, remember the tribunal's watching you, because they can see you behind the witnesses, and reacting to your own side's submissions or reacting to the other side's evidence is a bad thing.
Now, first things first, could you confirm your full name to the tribunal?
Philip Maxwell.
And your business address is Shepton House, 1 Carrier Road, Reading.
It is.
All right, now, Mr. Maxwell, could you turn to page 24 of the bundle there in front of you? And we should find your witness statement.
Here, we see how a witness may be asked to refer to documents in the bundle. Each witness gives evidence by reference to the bundle. They aren't able to use their own documents, such as their own notes, unless they're already in the bundle.
Is that your witness statement?
It is.
And could you turn to the end of the statement for me? Is that your signature?
It is.
And are the facts in the statement true to the best of your knowledge and belief?
They are.
All right. Could you go back to the beginning of the statement now, Mr. Maxwell, and read it to the tribunal, bearing in mind at all times that the tribunal need to hear what you're saying? Thank you.
The witness statement is one of the most important documents in the case, as it becomes the central evidence on which the tribunal will make its decision. When the witness reads the statement, his words become his evidence. Sometimes there'll not be a written statement, but this is rare. Increasingly, a tribunal will take a witness's statement as read. This means the witness will not actually read out the statement, but the written document is accepted as being his evidence, and this is becoming more common.
I've been the managing director of Hannigan's Brewery for 2 years. We have 7 pubs, and I'm responsible for overseeing them all. The claimant worked in the Come On in Reading. I'm familiar with the company's disciplinary policy, a copy of which is at page 40 of the bundle.
Right, Mr. Maxwell, sorry to pause you so early on. Could you turn to page 40 of the bundle?
As a witness, you must refer to each specific document so that the tribunal can take them into account.
Is that the policy you've just referred to?
It is.
All right. And sir, I'll be referring you to the relevant parts of the policy a little later on. Right, you can continue now with paragraph 2.
Towards the end of October, I found out that some customers in the Come On In. On the 25th of November, I wrote to the claimant and George Brown explaining why I dismissed them. I told them in the letter, page 34 of the bundle, that they could appeal within 7 days. The claimant wrote to appeal. This surprised me because both had said that they did not intend to appeal. The letter, page 36 of the bundle, was referred to the company chairman, Margaret Bradshaw, who conducts appeals. She asked me for a summary of what I knew and had done, and I set this out in a memo to her, page 35 of the bundle. I understand that an appeal was subsequently conducted, but I didn't take part in it.
Thank you, Mr. Maxwell. Please wait there, as my colleague will have some questions for you.
So, Ellen, we've heard what Philip Maxwell has to say. What's your job now?
I now cross-examine and put the claimant's case to the company's witness, which is the main point of cross-examination. I'll ask some searching questions in order to test their evidence and try and highlight the weaknesses of their case. Unrepresented parties get help with this with the chairman sometimes. It is very important that I challenge all the evidence with which the claimant disagrees, otherwise the tribunal will simply accept it. Let me give you an example.
Okay.
Before suspending Julian Kirby, what further evidence did you gather?
Nothing at that stage. I had the tip-off and the surveillance. My priority was getting him out of the bar.
Well, that's right. You wanted him away from the company premises, didn't you?
Well, yes. I suspected he was a thief, so I wanted him barred from the premises.
Well, at the point of suspension, you asked Julian Kirby to collect his belongings and take them home, didn't you?
Kirby was the one who suggested that.
Well, that isn't true, is it, Mr. Maxwell? You'd already made up your mind that both were guilty, which is why you told them to clear their belongings. They weren't coming back as far as you were concerned, were they?
No, that's not the way it was.
Julian Kirby's evidence is that he was told to take his belongings home, so I have to challenge Philip Maxwell's evidence that it was the other way around.
I think the best advice I could give either an advocate or an unrepresented party is that the success of the cross-examination is usually in direct proportion to the amount of time you put into preparing it. That doesn't mean you have to write down every question. What it does mean is you have to identify what are the issues in that witness's evidence that you want to challenge.
I tend to write out or type out a lot of my questions in complex cases. And the only reason for doing that is I need to cover every angle. I don't want to be criticised for not putting my case properly. And I tend to find that it allows me to go off track if I'm pulled off track by the witness, to deal with the point that the witness has raised and then go back to where I wanted to be.
Preparation is the key, and so I will map out the relevant issues in advance. I'll prepare the first few questions and certain questions that I have to ask, but I must listen to what the witness says and react to what they say, because they may say something unpredictable. I have to think on my feet. How many disciplinary matters have you been involved in before?
More than I care to admit, actually, but this one's out on its own.
What do you mean by that?
Well, the cheek of it.
Well, is that how it struck you from the beginning?
Absolutely.
Did you compare shift rotas for the 12th and 13th of November with the timing set out in the surveillance report?
Of course.
But there were lots of things which you could and should have done, but you chose not to.
I suppose I could have.
And if you had done those things, it would have made for a better investigation, wouldn't it? In unfair dismissal cases such as this one, the respondent has to show that it followed a fair procedure. The tribunal will therefore look at the respondent's own procedure and check that it followed it. It will also have regard to good practice, such as that set out in the ACAS Code of Practice. The code doesn't have force of law, but failure to follow it may mean that the respondent has failed to follow a fair procedure. I used the code when I was formulating some of my questions.
Can you tell people where to get hold of the code?
Well, the ACAS website would be a good starting point.
Are there any rules that have to be followed when you're questioning a witness?
Well, the strict rules of evidence, such as not allowing hearsay evidence or not allowing leading questions, don't apply in tribunals. However, tribunal chairmen may decide that they will adopt those rules depending on the case that they're hearing.
You mentioned leading questions. What are these?
Well, a leading question is when you try and lead your witness and put words into their mouths.
So you're saying a leading question is one that gives the witness the answer?
Yes.
How long have you got to cross-examine each witness?
Well, in theory, you have as long as you need, but you have to remember that the tribunal has set out a certain time frame in order to hear the case. Cases do overrun for all sorts of reasons. A tribunal chairman may not be happy if a case is overrunning because of lengthy or ineffective cross-examination. So remember, whether you are representing yourself or someone else, the key points about examining witnesses are: Know which points you want your cross-examination to bring out. Work out your questions in advance. Keep questions short and simple. Ask one question at a time. Listen and make notes of the important answers given. Don't be overly aggressive. Avoid making statements. Ask questions. Challenge everything the witness has said with which you disagree. Put your case to the witness.
Any questions from the panel?
Yes, please. You said you gave Mrs. Bradshaw a memo which is in the bundle. When did you prepare it?
I think I prepared them on the morning of the appeal hearing.
At the time of the dismissal, did you believe that Mr. Kirby was guilty of theft?
Absolutely. Even if he hadn't actually given away the drinks, he knew what was going on, and that's just as bad in my book.
Thank you, Mr. Maxwell. Miss Winston, do you have any questions to put to your witness in re-examination?
Once the cross-examination is finished, the tribunal will get a chance to ask the witness questions. Then the witness's advocate will usually get an opportunity to re-examine the witness. If new matters were brought up in cross-examination which weren't referred to in the witness's statement, or, for example, if a point had become particularly muddled in cross-examination, then a small number of questions may be asked.